Okay, 5,200. I really want you to just hold that massive number in your head for a second. That is the exact amount of people employed by Canada's actual largest law entity. We're not talking about some glitzy corporate firm in downtown Toronto here, but a single, publicly funded powerhouse. So let's dive right into this, because today we're tearing the roof off of a pretty massive assumption in the legal world.
Welcome to This Explainer. Today, our core mission is to completely shatter the myth that government lawyers are just regular corporate lawyers who happen to have a public employer. We're going to explore the hidden legal giants shaping our society and dig into why the old rulebook simply does not apply to them.
Now, the insights we're breaking down today come straight from a really pivotal Dalhousie Law Journal article by Adam M. Dodek. He basically argues for a completely unified vision of a government lawyer's ethical duties. Dodek points out that these professionals exist at a very specific, incredibly high-stakes intersection, right where public law and legal ethics crash into each other. And as we're going to see, treating them like any other private lawyer is actually a major problem.
The sheer scale we are talking about here is frankly fascinating. When we think of huge law firms, we immediately picture private partnerships, right? But Canada's biggest law firm isn't private at all. It's the Federal Department of Justice. Remember that 5,200 number from the start? Well, over 2,700 of them are lawyers. That makes the DOJ more than twice the size of the country's largest private law firm. And it's not just the federal level either. The Ontario Ministry of the Attorney General boasts something like 1,800 lawyers. These are absolute behemoths in the legal landscape.
And the explosion of public sector lawyers over the last 50 years is staggering. Back in 1961, only 6.7% of Canadian lawyers worked in the public sector. By 1986, that crept up to 10.8%. Fast forward to around 2008 or 2009, and we're looking at an estimated 15 to 25%. So let's just call it a solid 20% of the entire Canadian legal profession working for the public. Understanding their role isn't just some niche academic exercise anymore. It's absolutely critical to understanding the justice system as a whole. But to understand who these government lawyers really are, we first have to unlearn what we think a lawyer is supposed to be.
Section 1. The Zealous Advocate Myth.
Culturally, we are pretty obsessed with this idea of the fierce, take-no-prisoners advocate. This famous quote from Lord Brougham sums up the traditional adversarial model perfectly. An advocate knows but one person in all the world, and that person is his client. The standard idea here is that a lawyer is a zealous, morally non-accountable advocate who must do absolutely everything within the bounds of the law to help their client win. That's the image that dominates our media, our law schools, and our professional codes of conduct.
But here's the catch. When your client is the government, that entire model falls apart. Private lawyers are constantly balancing professionalism with commercialism. They have to worry about marketing, attracting clients, hourly billing, managing trust accounts, the whole shebang. Government lawyers, they have a guaranteed client. The state is quite literally the most reliable client in the world. They don't face that clash between making money and practicing law. Because of this, entire chapters of standard law society codes, rules about advertising or handling client money, are completely irrelevant to them. They're playing a totally different game.
Section 2. The Identity Crisis. Who is the client?
So, if they don't have traditional clients and they aren't hustling for business, who exactly are they working for? Well, the technical answer is the Crown. But what even is that? The Crown is a highly abstract social construct. One scholar actually called it an old family ghost that has lingered for centuries doing little but making its presence felt. It represents supreme executive power, it's a symbol of governmental authority, not a human being you can just call on the phone or take out for a coffee.
So, the crucial question is this. How does a lawyer take instructions from a symbol? This highlights the sheer absurdity of applying standard private sector rules to public sector realities. A private lawyer just asks their client what they want to do. Simple, right? A government lawyer, on the other hand, might have to navigate between the desires of a specific minister, the Privy Council, other bureaucrats, and sometimes even the Prime Minister's office. Decisions are often made by complex consensus. Pinpointing the client with any real exactitude is incredibly difficult.
And that ambiguity creates a massive risk: the danger of embedded lawyers and client capture. You see, government lawyers are often physically placed inside specific ministries, like transport or health. The advantage there is they learn the ministry's business inside and out. The danger, though, is they get way too close. They might develop a kind of misplaced compassion for the bureaucrats they work with every single day, accommodating political or policy objectives rather than providing stark, independent legal judgment. They forget they represent the broader crown, not just their office buddies.
Section 3. The Whistleblower Collision. To see exactly what happens when public law and private legal ethics crash into each other, we just need to look at these jarring discrepancies.
Under the regulatory imperative from the Nova Scotia Barristers Society, a lawyer absolutely must disclose information to prevent a crime, but only if it involves anticipated violence. It's mandatory, but very narrow. On the flip side, we have the Federal Public Servants Disclosure Protection Act. It says a public servant may disclose information about serious offenses or risks to health and safety. It's permissive, but much, much broader.
This creates an impossible real-world dilemma. If a Nova Scotia lawyer working for the federal government blows the whistle under the Public Servants Act because of a nonviolent health risk, do they get disciplined by their law society for breaking client confidentiality? Conversely, if they stay silent to protect their public servant oath, do they get disbarred? The current ethical doctrine simply does not have a framework for this. It's a complete ethical void.
Section 4. Custodians of the Rule of Law.
To fix this exact void, Dodek argues we need to establish a completely different standard for government lawyers. And you know what? We actually already do this for one specific type of government lawyer, the criminal prosecutor. Take a look at this iconic statement from Justice Rand in the famous Boucher v. the Queen case. The role of prosecutor excludes any notion of winning or losing. His function is a matter of public duty. We easily accept that prosecutors aren't supposed to be zealous advocates trying to win at all costs. Their fundamental job is to serve justice.
Dodek argues we need to take that exact logic and expand it to all government lawyers. Justice Borens in Everingham v. Ontario captured this perfectly, stating that a lawyer employed by the government assumes a public trust and may be said to have a higher obligation than lawyers generally. Whether you're drafting legislation, advising on tax law, or representing the state in civil litigation, you are carrying out duties that must be consistent with the Charter of Rights and the public interest. You are just an advocate, you are a custodian of the rule of law.
So how do we practically regulate these hidden giants? Dodek offers 3 solid proposals. First, we need specific codes of conduct tailored explicitly for government lawyers, totally abandoning that private sector rulebook. Second, proactive disclosure. We need to increase transparency around government legal policies. And third, the creation of an Office of Professional Responsibility within federal and provincial departments of justice. That way there's internal specialized accountability for these very unique public duties. Which really leaves us with this final provocative thought. If the Department of Justice and our provincial ministries are essentially the largest, most powerful law firms in the country, wielding the immense, unmatched power of the state, is it time we officially hold them to a higher standard than the private sector? It's a question that forces us to rethink the very ethical framework of our justice system. Thanks for joining me as we unpack the hidden giants upholding the rule of law. Catch you next time.